In Arizona, there is a facet of law called impaired to the slightest degree. Does that mean someone below a 0.08 will get charged with a DUI? Attorney Brian Sloan says, yes. In Arizona, there are two standard individual ways of being charged with DUI. The first one, you are driving, or your ability to drive, was impaired to the slightest degree by the use of alcohol, drugs, illegal prescription, and/or vapor-releasing substances. This is a more factual way of proving DUI. It is basically impairment. Also, it is driving, or being in actual physical control of the vehicle. The second way is more specific. You were driving, and you had a blood alcohol level at or above 0.08. Tested within 2 hours of driving. You had legal drugs or medication in your system. Legal can be prescription medication that is not taken as prescribed. So impairment can be by way of prescription medications. Even if you are taking them completely as prescribed, it is not a defense to you being impaired by prescription medications. It could also be impaired by vapor-releasing substances, which we most commonly see with paint huffing. You can see it, absolutely, with alcohol. In Arizona, there are presumptions of impairment. Someone tested at or below a 0.08 alcohol level is presumed under Arizona law to be impaired. If they're between a 0.04 and a 0.08, the law has no presumption. If they're between a 0.01 and a 0.04, they're presumed not to be impaired. However, in theory, the prosecutor could still choose to go forward at a trial and argue impairment, despite the law's presumption that someone is not impaired to that degree. For a free consultation, call Attorney Brian Sloan at 602-357-8980 or visit their website at www.arizdui.com.